So, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. So, today we are from Group The Inevitable. We'll be presenting on question number 3. So, I am NURFATIN binti ABDULLAH, and together with me is Sister Alia Balqis binti SYARHAIMY. Right now, let's move on to the scenario. So, the scenario basically is Tan Sri Baru, Datuk Sri Buruk, and Datuk Abah are members of parliament who won their seats during the recent general election. Tan Sri Baru is the minister in the cabinet in charge of legal affairs. He criticized the president of his party, who is the current prime minister, for not being brave enough to combat corruption among members of the party. And in a special meeting of the party later, it was decided that Tan Sri Baru was stripped of his membership and was no longer a member of the party. So the prime minister also announced that Tan Sri Baru has been removed from the cabinet and no longer holds the position of minister. Tan Sri Baru claims that the decision is unfair and arbitrary because he was not allowed to defend himself. Furthermore, he believed that the prime minister, who is also the president of the party, must respect his right to free speech and to criticize the party. Datuk Sri Buruk, a member of an opposition party, has been expelled from his party. He then forms a new party and becomes the president of the party. Datuk Baba, an independent member of parliament, pledges support to the current prime minister, the speaker of the Rakyat, then declares that Tan Sri Baru and Datuk Sri Buruk cease to be members of that house and their seat shall become vacant because they have changed party after being elected as MPs. Tan Sri Baru and Datuk Sri Buruk object to the declaration made by the speaker and argue that their rights to the members of political party have been deprived. Tan Sri Baru and Datuk Sri Buruk demanded that the speaker declare the seat of Datuk Baba vacant because he should also cease to be a member of parliament. However, the speaker refuses to do so. Then Tan Sri Baru and Datuk Sri Buruk bring legal action against the speaker in court to compel the speaker to declare that Datuk Baba has ceased to be a member of parliament. Discuss the situation from constitutional law and human rights perspective. So that is it for the scenario.
Moving on to the first issue, which is whether Tan Sri Baru expulsion and dismissal from cabinet violate his right to freedom of speech under Article 10, Clause 1, Paragraph A. So the rules is, we know that freedom of speech has been clearly mentioned in the Federal Constitution under Article 10, Clause 1, Paragraph A, which is it guarantees every citizen has the right to freedom of speech and expression, as you can see from the image below. Other than that, according to the Article 19 of Universal Declaration of Human Rights 1948, right to freedom of opinion and expression includes to hold opinions without interference. However, the Article 10, Clause 1 and Paragraph A, which is the freedom of speech, apply to who? So we would refer to the case of Dow Jones Publishing Co. Against Attorney General, in which this case is about a foreign media outlet, Asian Wall Street Journal, challenged a restriction on their publication. And the court dismissed the claim, holding that the freedom of speech under Article 10 is guaranteed only to Malaysian citizens and not to foreign entities. However, it should be noted that the freedom of speech is not absolute. This is because under Article 10, Clause 2, it allows Parliament to limit this right if it is necessary for reasons such as national security, public order, morality, international relation, or to protect Parliament privilege. And also, restriction can be made to prevent defamation, contempt of court, or inciting offences. And this shows that passing an ordinary law which relates to any of these ground, as I mentioned before, the freedom of speech and expression can be valid. We refer to the case of SYARHAIMY bin Shafi'i against public prosecutor, in which in this case the court highlighted that the fundamental liberties of freedom of speech does not possess an absolute freedom. This is because the court highlighted that the words under the law must be read after the passage in Clause 1, Paragraph A of the Article 10 of the Federal Constitution must be borne in mind that the freedom of speech and expression is not absolute right under the law and subject to limitations. Therefore, as I mentioned just now, passing an ordinary law to restrict such freedom of speech is valid. So one of the ordinary law is Sedition Act 94, in which from the Sedition Act, in Section 4, it provides that it is an offence to say or publish anything with a seditious tendency. And in Section 3, Clause 1, it's provide that speech that incite hatred against the government, insult the monarchy, or question protected constitutional matters like provision of Part 3 of the Federal Constitution or Article 153 or 181. However, in the Sedition Act, there is an exception in which in Section 3, Subsection 2, it provides that it protects acts, speech, words, publication, or other things to not to be seditious by only reason that, first, it has a tendency to show that any ruler has been misled. Second is mistaken in any office measure or to point out errors or defect in any government. The question here is, the Sedition Act is applied to who? So it is applied to everyone, even to the members of the parliament. Members of parliament here are not immune under the Sedition Act despite with their parliamentary privilege. This is because under Article 63 of Federal Constitution, it allows MPs to be charged with the Sedition Act. We refer to the case of PP against Mark Coding, which is, in this case, Mark Coding has been convicted under Sedition Act because he delivered a speech in a parliament urging the abolition of vernacular school, which is Chinese and Tamil schools in Malaysia. Therefore, this is because he questioning about the existence of the vernacular school could be seen as a seditious tendency under Section 3, Subsection 1. And it is also because it questioned matters protected by Article 152. Therefore, we would like to apply those rules into our application, which is about the criticism made by Tan Sri Buruk towards the current Prime Minister. So we know that it is stated in the Federal Constitution under Article 10 that every citizen has the right of freedom of speech and expression. Therefore, Tan Sri Baru criticism of the current Prime Minister can be constituted as his own opinion and expression. Tan Sri Baru, as a member of Parliament, is a citizen of Malaysia. Thus, he has every single right or constitutional standing to claim such right of freedom of speech as expression can be as can be seen in the case of Dow Jones Publishing and Attorney General. However, as I said before, every freedom of speech, it is limited. It is not absolute, as you can see in the case of SYARHAIMY bin Shafi'i against public prosecutor. Therefore, it is undeniable that Tan Sri Baru criticism of the current Prime Minister over the issue of corruption still needs to comply with restrictions set by the Parliament under Article 10. However, it has been mentioned just now. Article 10, Clause 2 has only allowed Parliament to limit the right if it is necessary for reasons such as national security, public order, morality, international relation, or to protect parliamentary privilege. It also can be made to prevent defamation, contempt of court, or inciting offences. However, based on the case, which is Tan Sri Buruk scenario, Tan Sri Baru scenario, Tan Sri Baru's statement were made as part of political critique regarding internal governance and anti-corruption, not to incite hatred, promote hostility, protect sensitive constitutional matters. Not only that, to apply, there's also no evidence in Tan Sri Baru remarks had any seditious tendency as per defined in Section 3, Subsection 1 of Sedition Act, distinguishing from the case of PP against Mat Kodi, where the members of parliament were convicted because he was touching about something vernacular code and also touching about Article 152. But in Tan Sri Baru criticism or speech, it did not touch upon any protected constitutional provision, racial sensitivities, or even incite any form of disaffection. His speech or critics falls even closer to the exception provided under Section 3, Subsection 2 of the Act of the Sedition Act, in which it explicitly protects speech made in good faith to point out errors or defects in government or administration with the intention to improve or correct such defects. Therefore, Tan Sri Baru criticism of the current Prime Minister alleged inaction in addressing corruption appears to be within this protected scope as it concerns with the issue of public interest and democratic accountability. So as a conclusion, Tan Sri Baru, as a Malaysian citizen and elected MP, has a constitutional right of freedom of speech under Article 10, Clause 1, paragraph A. His public criticism, being an expression of concern over corruption within the government, is protected speech under both federal constitution and exception to the Sedition Act under Section 3, subsection 2. Hence, the removal from cabinet based solely on the expression constitute a violation of his fundamental rights to freedom of speech.
Right, so moving on to the second issue, which is whether Tan Sri Baru and Dato' Sri Buruk's removal from Parliament violates their right to freedom of association under Article 10, Clause 1, Para C, and whether the Speaker acted lawfully under Article 49A. So basically, the rules is that right to association is guaranteed under Article 10, Clause 1, Para C, where all citizens have the right to join, right to form, and freedom of violation to form or not to form, to join or not to join an association. And the citizen has this right as long as they did not break any law. So basically, the exception is that as long as the citizen did not break any law, then he has the right to association. So every freedom is subjected to limitation, by which Article 10 of the Federal Constitution is the main legal prospect that will allow for anti-hopping laws to be passed. So this shows that Article 10 is also closely related to all the anti-hopping laws. So refer to one case, which is the case of Dewan Undangan Negeri Kelantan and Nordin bin Saleh, where in this case Nordin bin Saleh had been elected and resigned from his seat just to join another political party, and his seat was deemed vacant by the Speaker. This is because he resigned from his seat and not because of any grounds stated in Article 49A Clause 2 Para C, whereby in Article 49A Clause 2 it stated that grounds that whereby the Speaker cannot deem the seat vacant. So referring to Article 49A Clause 3, the Speaker has the power to deem a seat to be vacant by reason as stated in Article 49A Clause 1 and cannot declare the seat vacant by reason in Article 49A Clause 2 of the Federal Constitution. So basically, if a Speaker wanted to deem a seat vacant, it must be by reason that stated in Article 49A Clause 1, and it cannot deem the seat to be vacant by only reason stated in Article 49A Clause 2.
Now, with all of the rules provided, we are going to apply into Tan Sri Baru scenario. So referring back to Article 10, Clause 1, Paragraph C, it cannot be denied that all citizens have the right to association, including they have the right to join, right to form, right, and freedom or violation to form or not to form, to join or not to join an association. Therefore, in a plain, Tan Sri Baru is not an exception, as he has all the right provided in Article 10, Clause 1, Paragraph C. Nevertheless, while this right is guaranteed, it is subjected to limitation by Parliament under Article 10, Clause 2, Paragraph C, and Article 10, Clause 3A, which permits restriction through laws in Article 49A, which is anti-hopping party. And according to Article 49A, Clause 2, Paragraph C, it clearly states that a member of House of Representative shall not cease to be a member solely by reason of expulsion from his political party. Therefore, in Tan Sri Baru case, he indeed did not resign from his party voluntarily, nor did not join another party, but in fact, he was expelled as a consequence of voicing out his criticism. Indirectly, this expulsion falls under the exception in the Article 49A, Clause 2, Paragraph C, meaning that his seat should not be declared vacant. Hence, distinguishing from the case of Dewan Undangan Negeri Kelantan against Nordin Saleh, in which in this case, disqualification from legislative membership must be grounded in law passed by the Parliament and aligned with constitutional guarantees. He also resigned from his seat and not because of any grounds stated in Article 49, Clause 2, Paragraph C. Therefore, by declaring Tan Sri Baru's seat is vacant, which is clearly fall under 49A Clause 2, Paragraph C, it is wrong and invalid. According to Article 49A Clause 3, the Speaker may only notify a vacancy if it falls within the disqualifying grounds under 49 Clause 1. And since Tan Sri Baru expulsion is a ground excluded by Clause 2C just now, the Speaker's Act is unconstitutional. So as a conclusion, the removal of Tan Sri Baru from Parliament violates his right to freedom of association under Article 10, Clause 1, Paragraph C, as he is free to join any association after being expelled. And the Speaker's action was not lawful or unconstitutional under Article 49A because he was being expelled, hence he doesn't do any hopping party. Now, let's apply all of the rules for the situation of Datuk Sri Guru. So in the scenario, he is clearly he was expelled from his original party and subsequent from a new party and becomes its president. So again, Article 10, Clause 1, Paragraph 2 laid down that every citizen has the right to form association, including political parties. This right includes freedom to join, to form association, and not to be associated. Hence, Datuk Sri Guru, as a Malaysian citizen, was exercising his right. freedom of association when he formed a new party after being expelled. His action is not illegal, nor does it violate any statutory provision under Article 10, Clause 2, as it only allows restriction in the interest of national security, public order, or morality enacted by the Parliament alone. However, Article 10, Clause 3A mentioned that all of the members of House of Representatives shall be subjected to restriction imposed by Article 49A. Referring back to the Article 49A, Clause 2, Paragraph C, it provides a specific exception where and where a member of parliament shall not lose his seat merely because he was expelled from his political party. So this principle consistent with the case of Dewan Undangan Negeri Kelantan against Nordin bin Saleh, where the court upheld the speaker decision to declare the seat vacant because the elected representative had resigned from his party and hopping party, thereby voluntarily triggering the anti-hopping provision. In Datuk Seri Buruk situation, it can be distinguished whereby the Datuk Seri Buruk was expelled and therefore his case is different and falls within the express exception provided by the Article 49A, Clause 2, Paragraph C. Datuk Seri Buruk here was expelled from his original party. It means that he did not voluntarily resign or hopping party before his expulsion. And the operation of Article 49A, Clause 1, Paragraph A, 2 does not apply to him due to the protection provided by Article 49A, Clause 2, Paragraph C, or could be say he did not do any hopping party. When he subsequently formed a new political party after being expelled, it is within his freedom of association, and the act was done after he was no longer being a member of his previous party. It is not an act that constitutes a voluntary resignation or hopping party, which would trigger the disqualification under Article 49A, Clause 1. Hence, as a conclusion, the removal of Datuk Seri Buruk from Parliament after forming a new party following his expulsion does not violate his right to freedom of association under Article 10, Clause 1, Paragraph C, and the Speaker acted unlawfully or unconstitutionally to remove him from Parliament, as it is not in accordance with Article 49.
Right, so moving on to the third issue, where whether Datuk Baba as an independent member of Parliament who pledged support to the Prime Minister has violated the anti-party hopping law under Article 49A, Clause 1, Para B, and whether the Speaker's refusal to declare his seat vacant is inconsistent with the Constitution or violates Article 10, Clause 1, Para C. So under this issue, we had divided it into three sub-issues, which is the first one is whether Datuk Baba, an independent member of Parliament, has violated Article 49A, Clause 1, Para B by pledging support to the Prime Minister, and whether such support amounts to joining a political party. And the second one is whether the Speaker's refusal to declare Datuk Baba's seat vacant is inconsistent with Article 10, Clause 1, Para C of the Federal Constitution, freedom of association or otherwise unconstitutional. And the last one is whether the Speaker's refusal to declare Datuk Baba's seat vacant while declaring the seat of Tan Sri Baru and Datuk Sri Buruk vacant would violate the equality before the law under Article 8, Clause 1. Alright, so moving on to the first sub-issue, where it stated that whether Datuk Baba, an independent member of Parliament, has violated Article 49A, Clause 1, Para B by pledging support to the Prime Minister, and whether such support amounts to joining a political party. So as for the rules, Article 49A, Clause 1, Para B, where it stated that subject to provision in this article, a member of House of Representatives shall cease to be a member of the House and his seat shall become vacant immediately on occasion vacancy is established by the Speaker. Under Clause 3, if the person having been elected to the House of Representatives otherwise than as a member of a political party, he joins a political party as a member. This provision clearly stated that a member of a political party cannot join another party or else his seat will be declared vacant by the Speaker under Article 49A, is known as the anti-hopping law. So basically, we also refer to two cases which is interconnected because the first case is in the appeal court and the second one is in the Supreme Court. So the first one is the case of Nordin Saleh and State Legislative Assembly Kelantan, where in this case, Nordin bin Saleh had claimed that there is a violation of freedom of association under Article 10, Clause 1, Para C, as freedom of association includes the rights of not joining, right to form, and freedom of violation to form or not to form, to join or not to join. The court in the case held in favour of Nordin bin Saleh, as referring to Section 10, Clause 1, Para C, to compel a person by law to become a member of an association is clearly a violation of his fundamental right. So basically, in this case, the court is in favour of Nordin bin Saleh. So in the next case, which is Dewan Undangan Negeri Kelantan another and Nordin bin Saleh. So basically, the consequence of this case, Dewan Undangan Negeri Kelantan appealed to the Supreme Court, where the court emphasised that the law passed by the State Legislative Assembly Kelantan relating to the anti-hopping is unconstitutional, as it is contradicted with Article 10, Clause 1, Para C of Federal Constitution, and is in violation of freedom of association. In this case, a few candidates of the party represent and support the candidate of the party, meaning that they did not just support but they also joined as a candidate. But in this case also, the court held in favour of Nordin bin Saleh because on the ground that the amendment that had been made by Kelantan State Legislative Assembly is unconstitutional, as it is contradicted to Article 10, Clause 1, Para C. Right, to apply all of the rules in this scenario, it is crucial to be noted that Datuk Baba is an independent member of Parliament, which means that he did not join any political party. Thus, this clearly shows that Article 49A, Clause 1, Para B does not apply to Datuk Baba, as he is an independent member of Parliament. It should be emphasized that Article 49A, Clause 1, Para B stated that a member elected to the House of Representatives otherwise than as a member of a political party, he joins a political party as a member, where a member of a political party cannot join another party, or as his seat will be deemed vacant. As for Datuk Baba, he did not join any political party, and not just that, he only showed his support and did not fully join the political party. This can be distinguished with the case of Dewan Undangan Negeri Kelantan and Nordin bin Saleh, where in this case it stated that derived from the principle that a man may do what he likes and therefore associate with whom he likes, provided that no law is thereby broken. Hence, any restriction to dissociate from any association will make the current right ineffective and illusory, such as the right of the citizen to form, to join, or to resign from an association. So Dewan Undangan Negeri Kelantan passed an amendment where the court held that it was unconstitutional, and this was the reason why the government had passed a law, had made an amendment to our constitution, whereby they inserted Article 10, Clause 3A. So referring to this, it can be said that the act of Datuk Baba shows his support to the Prime Minister does not violate Article 49A, Clause 1, Para B, as he is an independent member of Parliament, and such support does not amount to joining a political party. So as for the conclusion, Datuk Baba did not violate Article 49A Clause 1 Para B, as he is an independent member of parliament, where his act of supporting the Prime Minister does not amount to joining a political party, as he did not become the candidate of the political party. He merely just showed his support. Thus, there is no problem with his act of supporting the Prime Minister and did not violate any law. Alright, so moving on to the second sub-issue, where whether the Speaker's refusal to declare Datuk Baba's seat vacant is inconsistent with Article 10, Clause 1, Para C of the Federal Constitution, freedom of association or otherwise unconstitutional. So as for the rules, Article 10, Clause 1, Para C of the Federal Constitution, where it stresses on the right of the citizen to association that includes the right to join, right to form, and freedom of violation to form, or not to form, to join, or not to join an association. And the Speaker must deem the seat of any member of Parliament vacant by reason stated in Article 49A, Clause 1, and his power vested to the Speaker can be seen in Article 49A, Clause 3. However, the Speaker cannot deem the seat vacant by reason stated in Article 49A, Clause 2. So basically, the Speaker had the discretionary power, but he is subjected to what had been stated in the Federal Constitution. So refer to this one case, which is Ronald Kennedy and another, and Datuk Johari bin Abdul disaman sebagai yang dipertua Dewan Rakyat and others, where in this case the court held in favour of Datuk Johari, who refused to issue the letter of disqualification due to the defective letters. This clearly shows that the Speaker has the power to declare the seat to be vacant or not, and it is fully on his discretionary to do so. Right, so in applying all of the rules to our scenario, the Speaker's refusal to declare Datuk Baba's seat vacant is not inconsistent with Article 10, Clause 1, Para C of the Federal Constitution, as Datuk Baba did not violate any law, as the essence of Article 10, Clause 1, Para C is that everyone has the right to association as long as they did not break any laws. Hence, the Speaker's refusal is consistent with the law and a right thing to do. Referring to Article 49, Clause 3, it is clear that the Speaker has the power to declare the seat vacant, but only by reasons stated in Article 49A, Clause 1. Datuk Baba, who is independent member of Parliament, who did not come from any political party, and he did not fall under the circumstances mentioned in Article 49A, Clause 1, which would disqualify him from being a member of Parliament, and his seat should not be deemed vacant. This can also be seen in the case of Ronald Kennedy and another, and Datuk Johari bin Abdul disaman sebagai yang dipertua Dewan Rakyat, where if a person loses his seat as he resigned voluntarily, the seat shall be vacant and he will be given letter of disqualification. The seat is vacant and somebody else needs to sit there in the assembly. However, Datuk Johari, who is the Speaker, refused to issue the letter, as it is said that the letters are defective as the person had done something which is not in line with the guideline. Thus, there was no notification by the Speaker and the seat was not declared vacant. It was held that the court cannot interfere with the business of Parliament, and the court is in favour of Datuk Johari. So this shows that the Speaker has the power to deem a seat to be vacant or not, provided that it is in line with the law. So in conclusion, the Speaker's refusal to declare Datuk Baba seat vacant is consistent with Article 10, Clause 1, Para C of the Federal Constitution, as Datuk Baba did not violate any law and justifiably exercising his right in Article 10, Clause 1, Para C, where he has the right to freedom of association. The Speaker had acted fairly, as Datuk Baba's circumstances did not fall under Article 49A, Clause 1, in which his seat should be vacant by the Speaker.
Now, moving on to the last sub-issue, which is sub-issue number 3, whether the Speaker's refusal to declare Datuk Baba's seat is vacant while declaring the seat of Tan Sri Baru and Datuk Sri Buruk vacant would violate the equality before the law under Article 8, Clause 1. So the rules here is referring to the Article 8 of Federal Constitution. It provides that all persons are equal before the law and are entitled to be equal protection to the law. This hence shows that every individual, regardless of their status or position in society, is subject to the same law. And equal protection of the law refers to the equal treatment under the law in which it applies equally and fairly all persons without unjustifiable discrimination or arbitrary distinction. Referring to the case of PP against Tengku Mahmud Iskandar, in which this court highlights that the status of someone does not define the law that would apply or applicable to him, and there's only one kind of law in the country which all citizens are amenable. Every citizen, irrespective of his official or social status, is under the same responsibility for every act done without legal justification. However, there are exceptions to this general rule that everyone is equal to the same law. So the exceptions are, first, it could be seen in the express exception that has been provided in Article 8, Clause 5. And also it could be seen in implied exception that use the doctrine of reasonable classification, which is a law that is not required to operate on all persons in any circumstances. Therefore, with the exception before I mentioned, a law is not required to be general in character and universal in application. So referring to the case of PP against Su Liang Yu, in which the court held that no person shall be denied equality before the law or equal protection of the law. But Article 8 does not prevent Parliament from making a law based on or involving some classification. This case emphasizing that a discriminatory law is a good law if it based on a reasonable or a permissible classification. Therefore, this case actually portrays that it does not mean that all laws must apply uniformly to all persons in all circumstances everywhere. Therefore, it could be said that equality provision is not absolute. We could refer back to the exception as I've been mentioned before. And now, we would apply to the Datuk Baba situation.
So to apply all of the rules in the scenario, the Speaker's refusal to declare Datuk Baba's seat is vacant, while declaring the seat of Tan Sri Baru and Datuk Sri Buruk vacant would not violate the equality before the law as stated in Article 8, Clause 1, where it provides that all persons are equal before the law and are entitled to the equal protection of the law. This shows that the decision made by the Speaker is fair and just because Datuk Baba did not violate any law, and not just that, he just showed his support towards the Prime Minister, which did not constitute a wrongful act. So this can be seen in the case of PP and Tengku Mahmud Iskandar, where it emphasizes that the status of someone does not define the law applied to him, and there is only one kind of law in the country to which all citizens are amenable. So every citizen, irrespective of his official or social status, is under the same responsibility for every act done without legal justification. However, there are exceptions to the general rule that everyone is equal to the same law. The exception would be express exception that have been provided in Article 8, Clause 5, an implied exception that use the doctrine of reasonable classification, which is a law that is not required to operate on all persons in any circumstances. In this scenario, Datuk Bapa is a normal citizen who is subjected to the equality of the law provided under Article 8. So we also apply the case of Piti and Su Liang Yu, where the court clearly emphasized that no person shall be denied equality before the law or equal protection of the law. Nevertheless, Article 8 permits the Parliament to make a law as long as it is reasonable and permissible. Applying this to the scenario, the Speaker made a right decision by not declaring Datuk Baba as elected. This is said as Datuk Baba was subjected to the equality of the law and should be treated fairly considering that he did not do anything wrong in the eyes of law. So in conclusion, the Speaker's refusal to declare Datuk Baba as vacant will not violate the equality before the law under Article 8 Clause 1, as Datuk Baba is subject to the law and he has the right to be treated equally unless he falls under the exception. So that is all from us. Thank you.